Hello, good evening, everyone. It's 12th April 2024. Time is around 11:30. So we're just right in time before we move on to the next day. And today being Friday night, all the corporate honchos must be partying around. In a way, I'm also partying, but of a different nature. This is more of a political party. This is my humble attempt to impress my daughter, and in a way, it's a promise of a papa to her daughter, to his daughter rather, that I'll be helping her in her competitive exam preparation. So, this is my small attempt. And based on her subjects, I thought there's only one domain where I can bring in little no value, and that was the English paper, wherein comprehension is an important part. And I felt nothing is more important, getting into the editorial analysis of the Hindu paper. It's easier said than done because it's been ages then that I have been out of all these kind of any studies or preparation specifically. So I tried to see that what is the current trend, and the best place was to go wherein the clat crackers are preparing. These are the platforms like an academy, then Legal Edge, Study IQ, and where I saw the young gurus, young teachers, and their energy is phenomenal. And hats off to their youthful energy, the commitment to the cause. And it's extremely difficult to match their josh and energy. However, a word of advice to all these young guns that never underestimate the power of a common Indian papa. So here I am trying to do my bit. So, with this little brief overview that why I'm here, let's get back to the task of today. And I'm surprised that Hindu is still very popular. I mean, in our days also, Hindi used to be the legend in terms of the quality of the editorials, and it was a very 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 happy revelation that today's generation is also banking on Hindu for their preparation. So hats off to Team Hindu for being the rock star of preparations, academic preparation or competitive exam preparation for so many years. So with this, let's come to the main topic. And primarily, there are two editorials. Generally, every day there are two editorials in the Indian newspaper. But today I'll only pick one because one of the editorial is primarily too political, and it's about the tripartite struggle of different parties in Telangana. That's too political in editorial, so I thought of skipping it. But fortunately, the other editorial is too good to be ignored, and it's in a way does justice to both the editorials of the day. So this editorial deals with the headlines, or it is titled as "Finality and Justice," and it deals some intricate developments of the arbitration between Delhi Metro Rail Corporation and one of their concessionaires called the Delhi Airport Metro Express Private Line Limited. एंड आइए थोड़े से क्रोनोलॉजी को समझते हैं कि आखिर ये क्रोनोलॉजी है क्या, शायद उसके माध्यम से we'll be able to decipher this editorial much better. So what happened? There was an agreement between the Delhi Metro Rail Corporation and an organization called DMEPL, that is Delhi Airport Metro Express Private Limited, which is primarily was owned by the Anil Ambani faction of the Ambani business. And they were given a contract to construct, maintain, and operate the metro line between the New Delhi railway station and the Delhi airport. Everything was going fine, but suddenly in 2012, this organization, the concessionaire DAMEPL, invoked the termination clause of the contract, citing that DMRC was not able to rectify few of the defects which they have highlighted. Now, obviously, when this sudden invocation of this termination clause left DMRC with no choice but to invoke the arbitration clause. And this arbitration went on. And in 2013, DAMEPL stopped the operations in June 2013 and handed over the line to DMRC. However, based on constant negotiation between the parties and keeping the inconvenience of the passengers into consideration, this was restored again. However, the arbitration went on, and in 2017, the arbitration panel gave the verdict in favor of DAMEPL, and DMRC was asked to pay a very staggering sum of compensation. It was close to around 8,000 crore rupees. Now, obviously, I know DMRC went into appeal. They went to Delhi High Court, and now Delhi High Court, in a way, the single judge bench of Delhi High Court upheld the arbitration award, and DMRC was asked to pay that amount close to 8,000 crore rupees. They again went into appeal, and this time the two judge bench, or the bench of High Court, set aside the award which was given by the first the arbitration panel and then by the single judge bench of the Delhi High Court. But now this time DAMEPL went to Supreme Court, and that was in 2021. So the two judge bench of the Supreme Court again set aside the award of the two judge bench which was given by the Delhi High Court, again asking DMRC to pay that huge cost back to DAMEPL. Now DMRC again, as any prudent arbitrator will do, went into appeal against the judgment of the Supreme Court. Obviously, or most likely, that was the outcome, that their appeal was rejected. Now, DMRC filed a review petition, which was also rejected. So finally, left with no option. I don't know whether the students who are preparing for CLAT, I'm hoping that you are aware of a special remedy of the Supreme Court, which is in the form of curative petition. It's an extraordinary remedy. Not very oftenly used, but yes, used in special circumstances, and primarily filed when the Supreme Court refuses to review its own judgment. And the grounds for invoking curative petition is that, first, to prevent the abuse of power, and secondly, to prevent the gross miscarriage of justice. So DMRC went for a curative petition, and the curative petition is further founded on the principles that courts' concerns for justice is no less important than the principle of finality. Now, what is principle of finality? I request you to go Google search. If you're preparing for CLAT exam, I'm sure you would know this. But just to help quickly, though it may not be the perfect definition, but principle of finality means that against this order, this is the final judgment, is the final order, and there is no scope of reviewing this judgment or order. That's broadly the principle of finality. Now, as per India's arbitration laws, an award given by the arbitration panel can hardly be challenged, and but this was a special case. In fact, in a way, it's a case study that this case was taken to the level of curative petition. Now, what are the grounds? What are the grounds when any arbitrant or any disputant can go to the curative appeal? Is that Uh, no, in this case, no, it was a long process. That first DMRC meant no, did a statutory appeal to the High Court, then they appealed to the bench of High Court, then they appealed in Supreme Court, then a review petition was filed in Supreme Court, and finally it reached the curative petition. Generally, this is not the trend in case of arbitration, but this was an exception, and such exceptional cases only become landmark cases, which generally the legal practitioners refer to when they're disputing or when they're representing their clients in the courts, honorable courts. Now, as a final analysis, now the earlier two-judge bench of the Supreme Court, in a way, erred in setting aside the Delhi High Court's judgment, and they overlooked a very primary aspect of of this case, which was the certificate given by the no chief commissioner of Metro Rail Safety, and this certificate was very vital to get the case in favor of DMRC. Now, what is the outcome, or what underscores this case is uh, that the arbitrators and judges, it's important for them to get both the fact and the law right. Only one, being lopsided towards only one may not give the right relief to the disputant. And if we don't help the arbitrators get the disputant gets it settled during the arbitration stage, then a message will go to the commercial arbitrators that arbitration doesn't works, and they'll be discouraged from going to the arbitration panel, and then they will get entangled in the lengthy court proceedings, and which is primarily will defeat the purpose of arbitration. So, constant stretching of the idea of finality may not favor the commercial litigants. And also, no, DMRC being a government organization had the patience, courage, and energy and time, and maybe resources also to go such a lengthy proceeding, as we discussed, from a statutory appeal, then to an appeal to a bench in the High Court, then appeal to a bench in Supreme Court, then a review appeal, and then finally to a curative appeal. All the commercial litigants may not have that much of time, energy, and bandwidth to follow these lengthy procedures. So that's broadly sums up this editorial. I know it's not easy to understand in one go. Maybe you can see this video again and go through the editorial maybe twice over. Most importantly, there are many keywords or difficult words, I'll say, whose understanding the meaning of these words is very important. So let's start. I mean, some of the words, it's difficult to get all the words, but some of the words which I feel are very important. To start with, finality, which means final, the final order, which is irreversible, irrevocable. Exorbitant, most of you would know, but still excessive, too large. In this context, the amount ordered was exorbitant. I mean, 8,000 crore is no less an amount. Concessionnaire means somebody who has got the contract to run a project, for example, a metro line, a toll plaza, or the food outlets you see at the airports or railway station. So these are official operators who have been given the rights to operate for a particular duration on certain terms. Then vindicates, which means to prove something, to justify. Flags means raising a concern. Finality in litigation we have discussed. It's a concept that dispute must achieve a resolution, and to that resolution there cannot be any further appeal. Substantive means having substance, which is in a way substantial, absolute, authentic, undeniable. Then perversity, This perversity is slightly different from the common reference. This perversity refers to legal term, which in a way means contrary to legal evidences, wrong-headed, unreasonable. That's what it means. Then patent illegality. This is again a purely legal context. So this means that deemed contrary to legal provisions. So patent illegality means contrary to the legal provisions. Then the next word is remedy. And it is a normal word. So remedy means anything which helps you to get relief from something, a solution, a treatment. Then miscarriage. Again, this miscarriage refers to the legal aspect. So something which a great wrong, failure of something, breakdown, setback in legal terms. Inexpedient. This means injudicious, unwise, not suitable or reasonable. Underscores, which means highlights, substantiates, emphasizes. And lastly, lest, which means otherwise, else. So these were some of the words which I could relate that these are important and slightly difficult for students to grasp. But I know you're smart students, most of you would be knowing it. So that's all for today. And hope my humble effort is of some value to anyone who's preparing for CLAT exam or any competitive exam where English comprehension is part of the examination. Most importantly, it's a fulfilling a promise to my daughter. Hope I'm able to impress her a bit. Like all fathers, who keep trying to live up to their kids' expectation. I'm also part of the same league of parents. So thank you so much, and I'm sure you'll be working very very hard to realize your dreams. Keep working hard. You guys are too good, guys and girls. You're too good, and I'm sure if and you are consistent, even if you're not too bright, doesn't matter. No one is bright here. If you're just consistent, focus, and you love your goal, I think you'll be home. So with this, thank you so much. Have a great day. I'll try to do the editorial tomorrow. So keep watching for this space. Thank you so much. Good night. Bye bye. Take care of yourself.